an easy explanation of the law of tort. Let's do it with examples because that's the best way to understand. So here's example number one. I'm walking down the street here in the town where I live, and I go past a very old and famous bakery. It's a family bakery and it's been there for a long time, maybe 60 years. And outside there hangs a metal sign quite high up above the door of the bakery that says Angel Bakery and the year that it was established. And all the old men in the town, the dads in particular, look at the sign and say, that's been there for a long time. Someone should make sure it's safe. If it's windy, it could come down and hurt someone. And being dads, they say, could kill someone if it hits them on the head. Well, I'm walking along the street. It's a slightly windy day. It's not a hurricane. And the sign comes down and it hits my shoulder and it hits my foot. Now that means I can't work for a few weeks. I need surgery in the hospital and I'm extremely upset. What area of law are we in your country? Because in England, we are very much in the law of tort. That area of tort is called negligence. And negligence means you failed to be careful when the law said you had a duty to be careful. We call that duty, she says, remembering, the duty of care. It comes from a very famous case in English legal history, and it basically says even when people are strangers, like me and the family that own the bakery, you still have a legal duty to be absolutely careful and not cause harm. So the first area of tort law is the biggest one, and it's negligence, a breach of the duty of care. So if I want to go to court, the owner of the bakery has committed no crime. There's no point in calling the police. And of course, there's no contract between that family and me. We're absolute strangers. So here we are in the law of tort to find a solution to the problem, a solution we call a remedy for breach of the duty of care. What do I want? Money. How do I get that money? Well, I have to explain to the court, be quiet birds, I think they're hungry. I have to explain to the court what my losses are as a result of this breach. Number one, loss of earnings because I can't work. Number two could be hospital bills, but in England hospitals are free, so probably not. And the third one is what you would probably translate as moral damage, but you can't say moral damage in English law. You have to say something like emotional distress, or if you're American, maybe emotional pain and suffering. So the law of tort will give me a remedy for the breach of the duty of care of the bakery. They should have maintained their sign and made sure it was safe. They didn't do that. A member of the public is injured. We've got a negligence claim. So that's the biggest and most important area of tort, negligence. Second example, I've got a lovely house here with a big garden. This isn't it behind me. I wish it was, but it's not. And at the bottom of my garden is land belonging to the railway company. And I notice on that land at the bottom of my garden, there's a very dangerous and expensive plant. It's called Japanese knotweed. It was brought here by the Victorian people a few hundred years ago because they thought it was beautiful, but they should never have brought it because it's what we call an invasive plant. And the reason it's dangerous is it's very hard to kill and it can grow through concrete, up through the foundations of a house. So I inform the railway company, you've got Japanese knotweed and it's very close to my house, and they do nothing. And the knotweed, of course, spreads very quickly. It comes under the garden fence into my garden, and now I cannot sell my house. I cannot sell my house because no one will buy it. This plant will destroy the foundations of the house. There's no crime. There's no contract. I will feed them, I think, after I finish recording. No crime, no contract. What do we have? Tort. And this is the tort of nuisance. And this is law that says I have the right to quiet enjoyment of my own land. I have the right for nothing to interfere with my peace and tranquility when I'm on land or in my home if I own them. And the railway company have caused me a nuisance, and I can take legal action under the law of tort. So tort really is an area of law where people have an argument, but no crime has been committed and there's no contract between them. But one of them is extremely angry and would like some money. There are other heads of tort. Heads just means categories. We've looked at, very quickly at negligence and nuisance. And in another video, we'll talk about a third one, defamation. Defamation is writing or saying something about someone that's not true and it harms their reputation. And I think in your system that just might be a crime. So let's talk about that another day. I'm off to give some bread to those birds now. Let's talk about the story of Mrs. Donahue, probably the most famous woman in all of the common law. So about 100 years ago, Mrs. Donahue left her home in Scotland to go and meet a friend in a nearby local cafe. The friend had invited Mrs. Donahue, which becomes important later in this story because the friend paid. It was just a cafe, it wasn't a posh restaurant. So Mrs. Donahue ordered a pear, the fruit, a pear, and a drink called a ginger beer. Ginger beer isn't alcoholic. It's what we call a soft drink. It's just like Pepsi. You probably wouldn't like it. It's a fizzy English drink with ginger in it. And that's what she ordered. And it came in a brown glass bottle. So Mrs. Donahue talked to her friend. She ate her pear. And she slowly poured her ginger beer out into a glass and drank it bit by bit. And then she got to the bottom of the bottle. I'm saying a lot in this story because everything about it displeases me. She got to the bottom of her glass of ginger beer and out came something disgusting, the decomposing body of a large snail. She claims that the next day she was very ill and also that she suffered shock. Remember, it's 100 years ago. People were maybe a lot more easily shocked than they are now. And she tried to bring a legal claim against the owner of the cafe, Mr. Mincella. Sounds like it was an Italian family cafe. So good luck, Mrs. Donahue, with that. And actually, she didn't get very far. If you know contract law, you know that you have to be party to a contract to make a claim under that contract. Mrs. Donahue was a third party, because she didn't pay. The contract is between her friend and the cafe owner, Mr. Minchella. Now remember, it's 100 years ago. Consumer law for the public was not what it is now, and she felt there was nothing much she could do. But she found a young Scottish lawyer, Mr. Walter Leachman, also very famous in the common law, and he went to court and said, look, even where there's no crime and no contract, there absolutely should be liability in cases like this. So he went to court with that argument, and this was the first recorded case of negligence in the British legal system. The judge in this case, Lord Atkin, in the very highest court, said there is a thing called a neighbour principle, that even when there's no crime and there's no contractual relationship, people have to be careful in certain circumstances not to harm one another. And if they do, they have to pay compensation. So Mrs. Donahue has become famous in English legal history, the lady who got the snail in the bottle, because her case, led by solicitor Walter Leachman, was the establishment of the law on negligence. And if you think about it now, in the USA and the UK, people go to people go to court all the time, on the basis of you were negligent, you weren't careful enough, and that caused me harm. So we've got medical negligence. I haven't been drinking ginger beer, I promise. I'm just on a very windy hilltop. Medical negligence, dentists' negligence, lawyers' negligence. They're all types of professional negligence. But if you are just not careful when you're riding your bike and you hit a pedestrian, or you're just not careful if you're a theatre and you sit someone too close to the orchestra and they say, your negligence has affected my ears. It's really big in our system now, but it all started with Mrs. Donahue meeting her friend for a pear and a bottle of ginger beer. How can you get a big advantage in your career that puts you in front of every other law student in your year at your university? Well, the answer is to know real commercial legal English that your future employers want from you. I'm going to give you a quick example, and you can use ChatGPT or Google Translate to help you with this. So, you're going to think this isn't legal English. It's not academic legal English. This is from work. What I want you to find out is the name of your country's central bank. That's number one. Mine is the Bank of England. What's yours? And the second thing, which is a bit more difficult, is to find out today what the base rate is at your central bank. The base rate of interest, BASE, base rate. When you've translated that and you know what that percentage is, you're ready for your first true legal English lesson. Right, the shirt I'm wearing here, I looked, is from Turkey. And in fact, a lot of British clothes are made in Turkey. There was a contract between Turkey and England to produce this and thousands of other shirts. Let's keep it easy. Let's say the bill from Turkey to the English customer was £100,000. £100,000. You are the lawyer in Turkey, and I am the lawyer in England for these two clients. So the Turkish client manufactures these shirts, my client in England buys them. Let's look at one sentence from that contract, and this is a sentence they will not teach you in university, but your employers want. When Turkey sends the shirts to England by ship or by plane, could be either, they issue an invoice. Now, invoice is just another word for bill. What's the difference between a bill and an invoice? Well, in a restaurant, you get the bill, but you cannot ask for 30 days to pay. You have to pay it immediately. An invoice usually gives you a period of credit to pay, 30 days, 60 days. So Turkey issues the invoice to my client in England, and my client agrees in the contract to pay within 30 days. Next word is deadline. The deadline for something is the latest possible day that you can do it. So imagine the deadline for my client to pay Turkey is the 1st of November. It's a Monday. It's not a public holiday, so it's a normal business day. That's what my client agreed to in the contract, to pay within 30 days with a deadline, a final day of the 1st of November. Now, contracts exist because people behave badly. That's the reason for contracts. So the contract anticipates my client either not paying at all or, much more probable, paying late. What do you think the contract will say about my client if my client pays late? Well, now we're coming to base rate and central bank. What the contract says is if my client pays late, my client agrees to pay interest as a penalty on the outstanding sum. Outstanding means not yet paid, it's late. The outstanding sum, we agreed, is £100,000. So my client didn't pay on time and now has to pay interest on that £100,000. How much interest? Well, you might want to say 2% of the total or 5% of the total. But lots of British and American contracts don't do that. What they say is if the buyer, my client, pays late, they agree to pay interest on the outstanding sum at a rate of 2% above the base rate at the seller's bank. Let me repeat that. They will pay interest at 2% above the base rate at the seller's bank. Now, the seller is in Turkey. The seller's bank refers to Turkey's central bank. It doesn't mean HSBC or Monzo or whatever bank the seller has. It's the central bank of Turkey. Whatever the interest rate is, my client will have to pay 2% more than that. Now, the base rate might be 2%, might be 10%, might be 25%. So You have to warn your client, if you're me, that clause, that provision in that contract is a little bit dangerous, because if you pay late, we're not completely sure what the penalty interest will be. We only know it's 2% above the base rate. So this is the type of commercial awareness, the type of English that your employer wants you to have, that university does not teach you. I don't know any university that teaches that English to young lawyers. Maybe Harvard, I don't know. I think they're a lot more practical. So here's your homework. Translate this into your first language. If the buyer pays late, the buyer agrees to pay interest on the outstanding amount at a rate of 2% above the base rate at the seller's bank. That's legal English. If you have a legal English teacher who's giving you 8 great verbs to use in meetings, that's helpful, but it's not legal English. So stay with us. We will teach you real commercial legal English, and we will go on giving you an advantage over every other law student in your year at your university. Bye for now.